So from Unit 2, we have this topic called charge.
Yes.
Is charge and what is the purpose of charge? So charge is nothing but in order to start with the criminal proceeding, right? Charge sheet would be filed or challan would be filed. So it has to be decided that what are the charges against him, what are the specific offenses or sections under which the person is charged, like what is the wrong which he has committed. We need to clearly specify it, because once the criminal proceeding starts, we want to make both the parties, everyone clear on what is the matter all about, right? What is it that they are trying? Everything has to be clear. So charge in simple terms, it means informing the accused person of the grounds on which the accused is charged. Only when he knows what are the offenses that he is accused of, what are the provisions, what are the punishments and everything, he can prepare for his defense, or he can try to provide evidence and everything, right? It becomes possible. So it's just a way of informing the accused person, like a formal way of informing the person that what are the charges based on which he will be tried in the court.
Yes.
If we talk about the definition under CRPC, it's given in section 2B of CRPC. That states the charge includes any head of the charge when the charge contains more than one head. Now, it might happen that one person has committed one wrong. Okay, take for example, check bounce. He has given a check to another person and the check got dishonored. So it is check bounce. Apart from check bounce, mostly we see that case will be filed under Negotiable Instruments Act section 138, 142 plus. Okay, along with that, sorry, this is 142. Along with that, they will also add provisions of IPC. Okay, they would include provisions of 140 IPC and all. Yeah, cheating. Right? So that means they have otherwise done one thing only, but they are adding too many sections together. Right? So in such cases, all these would be charges, like 138, check bounce is also a charge, 420, that is also a charge, cheating is also a charge. Okay, so this is what they have meant. So each would be considered as specific charges, and based on that, his trial would go on, and it would be decided whether he is guilty, he is acquitted, whatever is the situation. There was one case wherein it was explained that the purpose of framing charge is to give information to the accused, which is drawn up according to specific language of the law, and giving clear and unambiguous or precise notice of the nature of acquisition. Okay, so it's very much important that the person knows that what is it that he is accused of. Like in case of cheat, this, right, check bounce, take for example 138. Okay, we know that maximum punishment may be up to 2 years of imprisonment or fine double the amount of check. But when it is section 420, punishment can be maximum of 7 years. So only when it is very clear and unambiguous that these are the charges, we know what is the nature of acquisition. We know how serious is it, what might be the maximum punishment, and all the details we know. So that is the main thing what charge is. Sometimes you would also see that cases filed. Take for example, this happens, right? FIR is filed. In FIR, they have mentioned like 5-6 sections. But after doing like a preliminary investigation, police finds out that no, some sections are just added for the matter of adding. They do not carry any meaning, or it's not relevant as such. In such cases, police officer can also remove those. So just having the FIR is not enough, because from FIR addition, deletion might happen. So it has to be properly framed. It's like a formal way of informing the person. These are the charges. Hey, before we continue, I wanted to inform you about my live mentorship program for LLB students or law aspirants. Law subjects and law topics need detailed clarity. We get that with the help of cases, examples, and detailed explanation. It's definitely not possible to include everything in these short videos. If you find my videos easy to understand and you are looking for some professional help in preparing for your examination, you can join my live mentorship program. Here you will be getting exam tips, answer writing skills, detailed notes that you can refer for your examination, cases, examples, and in a very easy way topics will be explained. I have live classes going on for a lot of subjects as of now. To know more about it, you can drop me a message on this WhatsApp number. I'm also helping a lot of students in writing their assignments. If you need any such help or for any queries, any suggestions, you can drop me a message on this WhatsApp number. And now let's continue with our video. Okay, then we have purpose of charge. The main principle of criminal law on informing accused on the charge against him is to provide an equal opportunity to each and every individual to prepare his defense and avail the justice. When we know that these are the charges, we have an idea that these are the probable questions which would be asked in the court. These might be the defenses that I can produce for my defense. Everything becomes very clear, and that's the main purpose, that the accused person should be knowing it so that he can prepare his defense well and he gets equality as well. Okay, he gets equal opportunity to defend himself in the court. It must be noted that in case of serious offenses, the statute requires the charge to be reduced in writing precisely and clearly and must be read to the accused and explained with precision and clarity. Also, what are the charges? He will be informed that these are the finalist charges for which you will be tried. Do you plead guilty or you do not plead guilty, right? And it's very much important that he is informed that these are the acquisitions that are there. When we talk about what a charge contains, it would mention the offense, right? Offense or offenses, how many ever there might be, that the person is charged with. The charge from self specify the exact offense name for which the accused is charged. Like take for example, when we look at might be the Indian Penal Code. There what happens if you talk about section 420, for example. So section 420 also contains provision of cheating, 15 also cheating, 16 cheating, 17 cheating, 18 cheating, but punishments are different, right? For this one, punishment might be lesser, for this one, it might be severe. So it's very important that clearly it is specified, not like a person is accused of cheating, but it has to be specified, is it cheating and dishonestly inducing delivery of property, or what kind of cheating is it, that has to be specified. So it is that along with the section, the name of offense also will be mentioned so that it's very much clear, there is no confusion as such. In case there is no specific name given under any law for the offense with the accused is charged, like some cases, okay, fine, check bounce, cheating, sometimes it's very clear, we can just say one word and we understand the meaning, like theft, murder, we don't need to give an explanation as such, it's understood. But if it happens that something is mentioned that doing this certain thing is wrong, but as such a name is not given for that offense, in such a case, the definition would be given that this is what the thing is all about, right? Like the explanation or the what this offense is all about, that would be mentioned so that it becomes very much clear for the person to understand that, okay, this is the offense of which I am charged.
Yes.
The law and provisions of law to be mentioned in the charge form. Also, it would mention what are the sections, which are the legislations, everything will be mentioned. That also needs to be specified. It would be written in language of the court. The accused shall be informed with his previous allegations, which would expose him to enhanced punishment if guilty of offense charged. So it would be mentioned in language of the court, properly in court language with sections and everything, it would be written. Now, what is this last point? It says if there are previous allegations, sometimes it happens that if an offense is committed by a normal person, punishment is this. But if it is like a repeated offender, second time he is committing, punishment is higher. Or someone already convicted of an offense is committing it, punishment is higher. Have you seen any such provisions?
Such provisions I studied in first
IBC.
semester.
First semester, yeah. So there are many such provisions wherein specific things are mentioned that for first time offenders, this is the punishment, second time this, third time this, like the punishment becomes higher. So in such cases, previous allegations also need to be specified because it might enhance punishment of the person. So it has to be very much clear on what are the charges. Okay, there was another case wherein court held that mere mentioning of the section under which the accused is charged without mentioning substance of the charge amounts to a serious breach of procedure. So it's not that just sections are mentioned, sections plus heading or might be name of the offense. If offense is not named, might be definition. Details has to be there. Okay, that is the main thing. Now, it may happen that charges are filed that, okay, fine, these are the charges for which the person is charged and trial also starts. It may happen that at a later stage, okay, court shall have the power to alter or add the charge at any time before judgment is pronounced. Before judgment is pronounced, during trial, court may make changes as well in the charges. Okay, like court might feel that, okay, fine, FIR was filed under these two sections, charge sheet also these two sections are mentioned, but actually this other section does not make any sense. This should not be there. So in such cases, court can make alterations and all as well. Or if court feels that something else needs to be added, that can also be done. The trial court or appellate court may either alter or add the charge provided only that accused has not faced charges for a new offense. The accused must have been given opportunity of making the defense. Whatever new sections, new charges are added, for that also he should be given enough opportunities so that he can defend himself. Okay, but yeah, changes can be made at a later stage as well.
Yes.
After such alteration or any addition made to the charge shall be explained to the accused as to enable him to prepare to meet the fresh challenges. Initially also he would be informed that these are the charges, do you plead guilty or not? Later on, if any changes are made, there also accused has to be very clear. He should understand what are the charges against him. So again, explanation would be given. He would be informed about all those fresh charges which are being added or whatever might be the situation. If the court concludes that alteration or addition of the charge is likely to be prejudiced to the accused or prosecution, then the court may proceed with the original trial or adjourn it. The case shall not move forward unless sanction is obtained in respect of facts constituting the offense. So whatever court feels is necessary, that would be done. If court feels these new sections, new provisions can be added, they would add it, they would proceed. If they feel some time is required, they would do that as well. Okay, then there is just this conclusion that is very important in the charge. Acquisition and everything is mentioned so that the person gets an opportunity to defend himself, he properly understand what is this trial all about, and he can give his defenses accordingly.
Madam, the alteration during trial by way of removing any charge, that also to be informed?
Yeah, that also will be informed that these are the charges which we are removing. Sometimes it may happen that plea bargaining and all might come into picture, that if you plead guilty for these certain things, we are going to like remove some of the sections or some of the charges against you. Have you studied evidence yet?
No.
Not yet. Okay, you would get one concept of plea bargaining. Like we bargain, we bargain something, right? That, okay, give me this for this much, like that. Charges also can be bargained. Okay, plea bargaining, where the person would say, like it happens, right? Take for example, there is a situation wherein 5 people committed dacoity. Okay, 5 people were there who committed dacoity. Plus, there were some other minor charges also. Now, police officer could catch only 1 person out of 5. police officer, their plea bargaining might come into picture, that you plead guilty, that along with these 4 people, you conspired the entire situation and you did this, did that. In such a case, we would reduce your punishment a little bit, because you have helped the court or you have helped the police officers to find the other criminals, right? So if you are helping in some way to end the trial within time, right, we can reduce your like guilt a little bit, punishment will be reduced. You would get one concept called plea bargaining. Okay, so in such cases, yeah, it can be reduced, it can be altered, whatever is done, the person will be informed accordingly. Is this clear?
Clear, madam.